Hello, Todd Halleck here today talking to you about probate. When people come to my office about estate planning, one of the main concerns that they always seem to have is, I want to avoid probate. We've done a good job of making sure everybody is concerned and fearful about the possibility of their estate having to go through probate and the time and effort and frustration that might bring to their children or family members. But most people don't really understand or even know what probate is, so I wanted to talk a little bit about what that probate process looks like. So what probate is, it's a court process that allows us to get assets that were once owned by a person who's now deceased to their heirs or to the people that they have named as their beneficiaries in a will. That process can be time consuming. It can be costly. It isn't always. Every state is a little bit different. It also allows us to deal with any sort of debts or liabilities that they had. But it's really a court-involved process where a judge at some level oversees the transition of assets from the deceased person to living people at the end of the day. So what is the process that we go through when someone passes away and in determining whether a probate is even necessary, and then what happens once we initiate that probate? So the first thing we do is we figure out, did the person own any assets that even need to be probated? In most states, there is a financial threshold in terms of the value of assets, and if you're below that financial threshold, then there is usually a streamlined process for being able to transition those assets from the deceased person to his or her heirs or beneficiaries. Depending on the state, if there is real property, land, buildings, those sorts of things, it may not matter what the value is. If those are held by the deceased person in their personal name upon their death, those may have to go through the probate process. Assets that are held in trust, assets that have beneficiary designations, those tend to not be probatable assets. Assets held as joint tenants with a right of survivorship, those are things that are going to, by operation of law or by contract, avoid the necessity of probating the asset to get them to a now living person. So if we've determined that there are assets that need to go through this process, the first thing we will do is file an application with the court. And this is going to be different from state to state, but many states have what they call informal or formal probate processes. And depending on the nature of the estate, it may need to go through a more formal process where you have hearings and the judge is more directly involved, or it may be more of an informal process where most of the matter is handled through paperwork and handled through the clerks of the court as opposed to directly with the judge. So we file an application. If there is a will, we're going to seek to have that will approved. If there's not a will, then that person has died in what we call intestate, and we will seek to have a person appointed according to state law who will then be in charge of administering the affairs of this person's estate. So once the application is filed with the court will review that application, and if all is in order and all of the heirs and other beneficiaries are given an opportunity to object, if there isn't any objection or if they waive those objections, then the court will issue what are called letters testamentary. This is really the key document that you'll need moving forward in administering someone's estate. Any business or county recorders or anything like that where you're going to attempt to transfer or deal with a person's affairs, they're going to want to see these letters testamentary that are evidence that the court has appointed you to be in charge of this person's estate. Oftentimes I run into situations where the probate was never filed, but because the will said son or daughter was in charge of the estate, they just tried to move forward. And as long as they weren't having to deal with anything in terms of a business or in terms of moving assets, they probably got along generally very fine. but once they actually needed to do something, they might have realized, hey, I need these letters testamentary, sometimes referred to as letters of administration, depending on how it's going on, to be able to actually accomplish their jobs as the personal representative or the executor of the estate. One thing to remember, that as the executor of the estate or as the personal representative, you owe what's called a fiduciary duty to the beneficiaries of that estate. That means you can't act in your best interest, you have to act in their best interest. So really important, and it's really dangerous territory, and you got to be really careful if you're going to be making decisions about investments or different things like that that may impact the beneficiary. So this is a point where you really probably need good counsel to make sure that you're making good decisions that are consistent with your fiduciary obligations. The first thing that you're going to do as the executor of the estate, as the personal representative, is inventory and appraise the assets. We need to figure out what the deceased person owned, how they owned it, and what is the value. And most states will have a time frame within which you are supposed to accomplish this inventory. As part of that inventory, we're also marshaling the assets, which means we're gaining control of those assets. We're making sure that homes remain insured. We're making sure that people can't just get in and walk off with property. So in addition to inventorying, we're also marshaling and, like I say, gaining control of those assets. The next step that we're going to take is to make sure that all creditors are notified. You may have seen these notices in the newspaper. That's one of the ways we notice creditors. We also may have to send them a letter directly if we know about a creditor. This allows us to shorten the time frame, usually within which those creditors can make claims against the estate, so that we can get the estate wrapped up and finished up in a timely fashion. So we send out that notice to creditors. They'll have a certain amount of time to respond to us and make sure that we know about those creditor claims. Once we have those, assuming there are enough assets to pay what we call creditor claims and administrative claims, we pay all those claims. The difference between creditor claims and administrative claims, creditor claims are going to be claims of debts that the deceased person incurred while he or she was alive. Administrative claims are going to be claims that are resulting from the post-death debts and liabilities, attorney's fees, court costs, accounting fees, those sorts of things. We're going to want to make sure that those folks can be paid off, that any taxes that might be owed are paid and handled. Then at that point, we're going to work on distributing assets to the beneficiaries. This can be really frustrating because once somebody passes away, beneficiaries want to jump to the distribution phase immediately, but really important that you wait, go through all of this, make sure there's enough assets there to cover the debts and liabilities of the estate before you start making distributions. I always tell people it's a lot easier to hold on to money, pay the administrative and creditor claims, and then pay make the distributions, than to make the distributions and have to try to chase people down to get money back. And as the personal rep or executor, you could end up being personally liable if you do that and we can't get the money back. So really important to do this in proper order and make sure those distributions don't happen until we know that we have enough to cover all of the expenses. Additionally, what we always recommend is even once you make distributions, hold a little bit back in retention to cover the next year's tax bill or accounting fees and some of those sorts of things that will come up. Once this is accomplished, all of the assets have been transferred out of the estate, there's nothing left. We're going to want to close out the estate, have that personal rep, have that administrator released from any further responsibility, and that's the end of the process. I hope this has given you a real helpful idea of what that process can be. Time frame for completing it, usually no less than about 6 months, could be a year or more depending on the complexity of the estate. Depending on the state you're in, there may be statutory minimum fees. Other states, like the state I practice in generally, things are more billable by the hour. But this is what happens if you find yourself needing probate, and that's what probate is. I hope this has been some help to you, and I'll talk to you again soon.